This is the plaintiff, Jeffrey Maysell. He says he agreed to buy a car from the defendant, gave him a deposit, and then went to the bank to get financing. Unfortunately, the bank turned him down, so the defendant offered his bank. That bank also rejected his loan application. And when he asked for a refund of his deposit, all he got was a big no. That's not fair. So he's suing the sneaky car salesman for the return of the $500 he gave him. This is the defendant, Jonathan Caviola. He says the plaintiff kept telling him he'd find a way to get the money after the banks rejected his loan applications. 7 weeks later, the guy calls him and tells him he still didn't have the money, but please hold on to the car because he'll get the money. 8 weeks later, he finally gave up on the guy because it was almost winter and he sold the car to someone else so he wouldn't take an even bigger loss. Now the guy's suing him for his deposit? Come on, man. He's accused of not waiting forever. The defendants filed a countersuit for $3,000 for money lost on the sale of the car.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case in the docket, the plaintiff made a deal to buy a car from the defendant, couldn't get financing, now wants his money back. But the defendant says it's the plaintiff's problem. It's the case of don't bank on me.
You're welcome in.
Jeffrey Maysell, you are suing Greenwich Motor Sales, represented here by the owner, Jonathan Caviola?
Correct. Okay,
for $500 of a deposit that you placed on a vehicle that you did not end up buying. You have a counterclaim against him for $3,000 for the difference in price that, according to you, you had to take as a result of him not buying the vehicle. All right, what happened?
Last August, I went to look at a car. I was looking to trade in my 2002 car, and they had a 2008 car that I was interested in trading it in for.
Right. What kind of car?
It was a BMW.
Uh-huh.
And my wife was 8 months pregnant at the time, so she said, "You've got."
Okay, 8 months, not 11 months, right?
Correct.
That was a typo in there. Okay, I was like, that's uncomfortable. Okay, go on.
So I went down and test drove the car. I liked it, and I came. We talked at the dealership, and they said that they didn't offer financing, so I'd have to do it through a third party. And I said I was interested in the car, and they said, well, you should put a deposit down and talk to our finance guy. So I applied for financing through Bank of America.
Did you put a deposit down?
I did. I put a deposit down.
And is there any paperwork regarding your deposit?
There wasn't. It
Okay.
was. It was a debit card. So they swiped it, and that was all that was done.
And what was your understanding of what the deposit was for?
To see if I could get financing, and if I could purchase the car, and if not, then.
Well, what does that do for them? I mean, isn't the purpose of the deposit to hold the car so they don't sell it to someone else while you're trying to get financing?
Well, they told me that they would recommend that that's what I do, and it was a refundable deposit. If I couldn't get financing,
Who said it was refundable?
The defendants did.
Watch this. Did you tell them it was refundable?
I don't really recollect. It's over a year.
Do you ever tell your clients that it's refundable, though?
Sometimes I do, but I've never, ever kept a deposit in 45 years in business. If he asked for a deposit back, he would have got it.
So why am I here? He asked for his deposit back.
No, he never asked for his deposit back.
Oh, you mean he waited too long?
Well, he waited at least 3 weeks. I turned down a solid deal on it. After my bank rejected him, he went on his own. And then he called back and he said he was having problems. He was still pursuing it. And then he called back maybe 2.5 months after that. And then I never heard from him again until...
He called back 2.5 months after that to say what?
After the initial deposit.
To say what?
He's still working on it.
Okay.
And then I never heard from him again until August when he emailed me.
A year later.
A year later.
So if the plaintiff couldn't get financing, does he get his deposit back? Does he get his deposit back if he could?
I think he should get his money back because he was putting it down on to buy something and he didn't get that product. So he should. Okay,
but is that really the car dealer's fault? I mean, if he gets the money, it's like your problem, right?
Yeah, tactically, I think they shouldn't get it back. It's unfair.
Fair enough. Going inside the courtroom.
Apparently, for just the way you do business is if people ask for their deposit back, you give it to them.
Absolutely.
But in this case, you don't.
It's a little bit unusual, I think. And I did lose a bona fide deal on the car, and I had to hold the car another 6 months.
Okay. But how do I know you didn't tell him your deposit's refundable?
You don't. I mean, I don't.
So how do
It's been so long, I'll be honest with you. He might have said something at the beginning If I don't get my financing, could I get it back? But I don't remember.
And you might have said yeah?
Maybe, yeah. I can't remember. It's over a year. But I would have given it back to him back then, to be honest with you.
Yeah, but the law doesn't let you change it because time passed. I mean,
No,
yeah,
but
you
even
should have
on
asked
our
for it sooner, but
On the retail
you know,
order,
it's either refundable, it's not. That's what the law is. And my default position is it's non-refundable, but not
don't
after your
remember.
testimony, because your testimony just now was I might have, and he's saying you did, and you're saying I always give it back, and I give all my. So maybe you did say it was refundable, and he's just a slack jaw and didn't get around to asking you for it fast enough. I don't know, but on testimony like that, how do I not return his deposit? That's a first. When I turned around and said, watch this, I expected you to say, hell no, Judge, those deposits are never refundable because they're meant to hold the car, and they're meant for this and they're meant for that. Now you have a counterclaim against him for $3,000. What were you buying this BMW for?
$28,000.
Okay, and what did you end up selling it for?
I sold it for 28, but it wasn't. Do you have the original order?
Nobody
I have
does.
my loan application from that week.
Yeah, but that's with the trade-in.
You were giving me a trade of $5,000.
Wait, 28 plus the trade-in?
Minus the trade-in. So
28 minus 5, so 20.
my
that's
application was for 22 because I had given the 500 and I was going to pay another 500.
Okay, let me see all that. I mean, did you have a signed contract with him to purchase the car?
I did, but it's been so long. At the end of the year, we got rid of it.
Okay, that's good enough for you. It's good enough for me too. Okie doke. Based on what I've heard on the plaintiff's case for a refund of his deposit, I am going to order a refund of the deposit on the counterclaim 0. That's my judgment.
Guys, both sides, please. Hold on right there.
And so just like that, the defendant finds himself out here in the hallway, step next to me on the losing end of this case. What's your reaction?
It is what it is. I mean, I don't think it's right, but that's what
Why
she
don't
doing.
you think it's right?
I wait a whole year to tell me you can't, buy the car.
You realize your own testimony kind of sank you in there.
I'm not going to lie. I can't remember. It's a year ago. What'd you say yesterday?
Huh?
I don't know. I really don't know.
Okay. All right. Head right down this way. All right. So, all right. You win your case. How'd this come out for you?
I think that the judge reached a right verdict on this.
Why did this have to come to court? He says he was willing to give it back to you.
Well, I contacted him via email. I made numerous phone calls. They weren't returned. The email that when I finally contacted him via email, he said he wasn't going to return it. So I figured I had to take it to the next level and suit.
Okay. What do you got, Harvey?
You know, there's a principle in the law. The law abhors forfeitures, which means if there's any way to get money back, then the judge will do it. And in this case, look, the defendant even kind of admitted it. So bottom line, plaintiff gets his refund.